Hello, everyone, and welcome to our presentation. We're going to be taking you through a walkthrough of the vocation rehabilitation process from knowing what your rights are to the VR services through appealing these decisions. So my name is Jana Scheiman, and I am the managing attorney of the Disability Rights New Jersey Employment Unit. We handle the client assistance program, as well as the protection and advocacy for beneficiaries of Social Securities, helping individuals to be able to reduce barriers to being able to find, receive, or keep working in the community. So we are the state designated protection and advocacy agency for New Jersey, and every state has a designated agency which receives federal funds to help investigate and monitor facilities where individuals with developmental disabilities are located to help ensure that they're not being the victims of abuse and neglect. And the role of Disability Rights New Jersey is to advocate for and advance the human, civil, and legal rights of residents in New Jersey with disabilities. The Client Assistance Program is a federally funded program that's designed to assist individuals who are seeking or receiving vocation rehabilitation or VR services who need some assistance. As a VR applicant, you have the right to contact the Client Assistance Program at any time in the process, whether you're applying for services, whether you've already applied and are trying to find out what's going on with your individualized plan of employment. If you have a disagreement about the services that are being provided, you can always contact the CAP program. We're able to help answer your questions, provide counsel and advice, and to help you understand your rights. And we may be able to provide legal services at no cost to help you through the process. And that's one of the most important things about the Client Assistance Program. We are a free service under the Rehabilitation Act of 1973 to be able to help applicants know their rights and be able to enforce their rights. So please do not hesitate to reach out to the Client Assistance Program, and I'll have our contact information at the end of the presentation. We're here to help. Today's presentation is brought to you in connection with the New Jersey State Bar Foundation, which provides no-cost educational programs to really help individuals in New Jersey understand the laws and what their rights are under their laws. The mission of the New Jersey State Bar Foundation is to foster and increase awareness, appreciation, and knowledge of law and the legal system among New Jersey residents, serve as a statewide resource for law-related education for the public, provide opportunities for attorneys to serve the public through foundation programs, and foster professionalism and pride in the profession of law through public service. Bar Foundation recognizes that we have a lot of statutes, we have a lot of laws in New Jersey, but not a lot of people may understand them. So that's why they've made it a mission to go out and help educate people so you know what rights you have and how the laws are there to protect you. So today, we're going to go over a variety of topics. We're going to start with your rights to employment assistance, an overview of the VR systems, eligibility for VR services, applying for these services. How do you develop an individualized plan of employment? How do you request the services and sponsorship? We're going to go over the comparable needs test. And then if you have a decision that you're not happy with the VR agency, how do you appeal that decision? How do you seek to find somebody else to look at your decision, look at the services that are being provided, and say whether or not they feel that it's appropriate or not appropriate? So we're going to start with the rights to employment. The rights to VR services come out of three areas. The first is the Rehabilitation Act of 1973, which was amended in 2014 by the Workforce Innovation Opportunity Act. And in 2014 as well, New Jersey issued a statement that said it is an employment first state. So what do those mean? The Rehabilitation Act of 1973 prohibits discrimination on the basis of a disability. Now, this again predates the Americans with Disabilities Act, but the Rehabilitation Act says that you can't discriminate against somebody in the process of getting a job, going to see medical treatment. This is where we hear Section 504, where there's no discrimination for agencies or for services where individuals with disabilities are receiving benefits. The Workforce Innovation and Opportunity Act is a United States public law that was codified at 29 USC 3101 et sec, and it wound up changing and amending the Rehabilitation Act to provide additional services and enhanced benefits. The Workforce Innovation Opportunity Act permits VR agencies to encourage eligible individuals to pursue advanced training in the fields of science, technology, engineering, or mathematics, including computer science, law, medicine, or business. Why is this important? The Workforce Innovation Opportunity Act is what gives the VR agencies the opportunity to be able to provide funding for graduate level programs, where prior they really would only provide services through an undergraduate degree, and you had to fight with them to be able to get graduate programs. So, this is why it's an important change. And this is also where, for students with disabilities who are still in the schools, they're entitled to pre employment transition services to be able to help get them ready to transition to life after high school. New Jersey is an employment first state. What does this mean? It means that employment in the general workforce should be the first and preferred options for individuals with disabilities who are receiving assistance from publicly funded systems. Essentially, this means employment first means real jobs and real wages for all people who are working. We have two VR agencies in the state of New Jersey. We have the Division of Vocation Rehabilitation Services, which is known as the General DVRS, and the Commission for the Blind and Visually Impaired, and you'll hear it referred in this presentation as CBVI. The rehabilitation agencies really exist to maximize employment, self-sufficiency of individuals with disability, independence, and inclusion and integration into society. And CBVI has a special niche that it provides services to. They provide services to individuals who are blind, visually impaired, or classified as deafblind. And DVRS provides services to all other individuals with physical, mental, or other forms of disabilities. Services that are available through both DVRS and CBVI to be able to assist someone in preparing for employment. You can get job coaching. Do you need somebody to go with you to a job to help train you, to help you figure out how do you perform the tasks? How do you move to a new department? They can send a job coach to be able to help you with that training. They may be able to assist you in securing job accommodations with your employer. The VR agencies are able to provide transportation services to help you get to and from work, or they're able to provide training to help you either get your driver's license, or if you're somebody who is blind or visually impaired, how to navigate the public transportation system so that way you're able to be more independent getting to and from work. They're able to assist with college and vocational training sponsorship. Are you looking to become a teacher? Do you know that you're going to need a bachelor's degree and a master's degree? The VR agency may be able to assist you with that. They're also able to provide physical and mental restoration services that are not already able to be provided through your insurance companies. And they're able to provide assistive technology if it will help you to be able to access or retain employment. And lastly, they're able to provide other goods and services that are determined necessary for an individual with a disability to be able to achieve an employment outcome. So this is all the other services that aren't quite covered in the other services we've outlined, but would still be something to assist you. They're able to provide vision training. They're able to provide psychiatric services. If it's not provided, being able to be provided through an insurance company, you can go to DVRS and ask them to make a payment or to provide the service as well. So how do you become eligible for these services? And we're going to separate them out between DVRS and CBVI. And DVRS, to be eligible for individualized VR services, the individual must have a physical or mental impairment that constitutes or results in a substantial impediment to employment. And to address that, they're going to require VR services to help them prepare for, secure, retain, advance in, or regain employment. So this isn't a service just for someone to help find a job. You can go to the VR agency if you're currently working, but you're looking to prepare for your career. And that's one of the big things that I do want to emphasize. This isn't just about getting somebody into a minimum wage job, to get somebody to be a cashier. This is helping you plan for what the future would be, regardless of your disability. What do you want to do? What would you like to be trained in? The VR agencies should be able to help. But the Commission for the Blind and Visually Impaired They're the agency that is set by New Jersey statute to help those who are visually impaired or legally blind. And they have a definition for those too. A visual impairment is somebody who, with their best correction, like I currently wear glasses, is at 20/70. So they're seeing at 20 feet when other people are seeing at 70. You're deemed legally blind if, with your best correction, your vision is 2200. You're able to see at 20 feet what somebody else is able to see at 200. An individual is also considered legally blind if there is a restricted visual limitation of 20 degrees or less. And this is where, when you currently are looking ahead, you most likely have 180-degree vision where you can see out the sides of your eyes. If somebody has a 20-degree narrow window and they're only able to see straight in front of them, that can qualify them as being legally blind. And CBVI will work with the school districts to help transition visually impaired and legally blind school age children from ages 14 to 21 to be able to prepare them for life after high school, where there's not as much services or as much support with them daily. The provisions of VR services to eligible individuals have several components, but the two that we're really going to talk about in this presentation is the services must be individualized. And for those of you who are part of the special education world, you're going to hear a lot of very familiar terms. Services must be consistent with the individual's unique strengths, resources, priorities, concerns, abilities, capabilities, interests, and their informed choice. You're going to hear informed choice a lot when you're talking about the VR agencies. And what does that mean? The legal definition is that an individual must be able to exercise informed choice throughout the VR process, including in the selection of their employment goal. So what does that really mean? It means that the person who is seeking the services is supposed to have an important voice as to what they want to do. If you're coming to the VR agency and saying, I want to become an attorney, they're not supposed to be looking at you saying, okay, we'll help you become a retail worker. Why? Because a retail worker and an attorney are not at all in the same field. You're supposed to sit down, have a conversation about your strengths, weaknesses, what you want to do, what outcomes you would like to achieve to come up with a plan that works for you. So there's an overview, and we're going to start with the DVRS process because most individuals with CBVI have already been identified before they finish the age of high school, before they finish the age of 21. They're already connected with CBVI through either the pre-ETS services, the Project Reach that CBVI provides. So with DVRS, you fill out an online referral. And this starts the process. This registers to the VR agency. There's somebody who's looking for assistance. Once that referral is filled out, there's an intake meeting, and that's where you will receive the application for VR services. There's determination of eligibility, the development of the IPE, the provision of VR services, and then obtaining employment and the closure of your VR case. In an ideal world, this is the process from start to finish. The first step is to fill out that online referral, and we're going to put the slides up on our website. I believe they may already be up in other presentations, but you can do a search for DVRS, and if you go to the DVRS website, on the upper right-hand side of the page, there will be a link that will say application or referral, and this is where you will complete the form. We will also, again, like I said, put the PDF of this presentation up on our website so that way you have access to this link. We have the DVRS referral form directly in the presentation, so you can go straight to the referral form without going through the DVRS page. With CBVI, you contact the main office for the referral, and they will assign you out to one of the field offices. For CBVI, I believe there are 6 field offices throughout the state, where for DVRS, there are 18 located throughout New Jersey. We have the website for CBVI here, and the phone number for referral. There are 2 numbers you can call. One is an 800 number, and one is the local number. You can start by calling the 877-685-8878. Or you can try 973-648-3333. Things to note during the referral process for DVRS. These are things that we do want you to know because you're going to come up with them and have to deal with them when you're going through the DVRS. Once you've completed a referral, DVRS will contact you and they will request documents or will try to set up an intake interview. And one thing we do want to note, because it's going to come into timing later, this will happen before you are given the actual application. And they will ask you for documents before you fill out that application. And these will include things like your driver's license, social security card, proof of your address, and tax documents. Why? Because when they're doing the tax documents, they're looking to see whether or not you're financially eligible, which we'll talk about a little bit later in this presentation as well. But one of the things that they're going to ask you for are going to be medical informations or releases. That will include a general basic medical examination from your physician, a mental health evaluation, and an authorization to release documents. And they'll ask you to sign those or send them to your doctors to be able to get the records from them to send to DVRS. Your first conversation with DVRS CBVI will be then the intake interview. And this is going to be an initial discussion. You're going to discuss what it is you're looking to do. What's your career objective? Let's have a discussion about your disability. How does it impact you? What do you think you would need to be able to succeed? And a discussion of your past employment and education. This meeting will not be what leads to the development of an IPE. This is what will give you the application for the VR services. Once that you'll be given the application there, and once you have signed it and return it, the VR agency has 60 days to make an eligibility determination. Note, that is not from the date that you first send in the referral. That is from the date that they received the signed application. If you are somebody who receives SSI or SSDI, congratulations, you're presumed to be eligible for services. What does that mean? It means that the Social Security Administration has already found that you have a disability and that you're entitled to benefits. DVRS and CBVI will take that eligibility and say that that means that you have a physical or mental impairment, which does act as a substantial impediment to employment, and that you are presumed to need the VR services to be able to get, find, or keep a job. There is a provision that individuals with SSI or SSDI are considered to be individuals with a most significant disability. And that comes into play if the state of New Jersey was in an order of selection, which meant individuals with the significant disabilities or most significant disabilities are served first. And then if there is still funds left over, the money goes down the rest of the eligibility tiers until they run out of funds. Right now, I'm happy to announce New Jersey is not in an order of selection. All individuals with disabilities are receiving benefits. So, what are some of the common problems that you'll run into during the eligibility assessment? We want to make you aware of these because these are things that you could face when you're applying for services. There could be a long period of time between when the referral is submitted and when you have your intake interview with DVRS. There is supposed to be a written policy that the VR agency uses to address the timeline to be able to say whether you'll be receiving contact within 2 weeks, 3 weeks, but it may be longer than anticipated, and we don't currently have a written policy. And when I say there may be a long time between when you file your referral and when you have the intake interview, we've seen clients that have sent out a referral in April and their intake interview was at the end of July. So that's 3 months they weren't receiving services because they still hadn't filled out the application. The next issue, the VR agency may request a certification from your doctor, not saying what your conditions are or not saying what the doctor has seen with you, but specifically asking if you are ready and able to work. Be sure to ask your doctor to provide you with the copies rather than sending any documents or any items directly to the VR agency so you can see what's in them and discuss them with your doctor. And one of the reasons why we recommend this, doctors can discuss your current state. They can discuss your physical limitations. They can discuss whether there's any accommodations that they think may assist you with to help with your mental health. But they're not qualified to say whether or not you're ready and able to work. That's really the role of the vocation rehabilitation counselors who work for DVRS and CVVI, all of whom have received specialized training in identifying when somebody is able to work or not to work. The other issue that we've seen a lot is DVRS may close the case without notice before making an eligibility determination. And with this, they're usually closing the case before you've even gotten to that application period. This may be that they receive a record from your doctor that says, we think this person may be a danger to themselves if they go to work in the community. DVR will say, okay, great. Then we want you to get that taken care of. Come back to us when you're ready. But because you haven't filled out an application, there's certain protections that haven't triggered yet. And so that's one of the things that you can contact the client assistance program because we've seen this more frequently than we should be. So once you've been found eligible for services, you're entitled to an individualized plan for employment. So what is that really? It's an important document because it really does define the services that the VR agency has agreed to provide to you. It's not a contract, but it provides significant weight if a disagreement does occur. For many of us that come out of the special education field, you're used to the IEP that a student receives that sets forth, are they going to receive three sessions of speech therapy a week, 4 sessions of physical therapy a week. That is similar to what this IPE will do. This is where it will outline, are you receiving job coach services? Who's going to be providing them? Are you receiving tuition sponsorship? How much is the VR agency paying? Who's paying for other services? And how much is the client paying? This IPE must be reviewed at least annually. And if necessary, it can be amended at any time if there are significant changes to your employment goal, the VR services to be provided, or if you're trying to change your service provider. Why? Because the IPE will set forth what agency is providing the specific service that's set forth in it for you. Just a moment. It is important to note, changes to the IPE will not take effect until everybody has signed off on it. We know that with special education, if you haven't disagreed with an IEP within 10 days, the IEP can be implemented. That's not the same with the VR agency. If an IPE is created, but it's never signed, it's never implemented. And so that's one thing to note. You have to agree to services, and there has to be an actual agreement between both client and the VR agency. The VR agency can't just unilaterally decide, here's the services we're providing, we're signing off on them and giving them to you. The client has to be involved. You as the individual who's receiving the services have to agree to those services. So what does it really include? It includes the employment goal. And this is supposed to be chosen by you or by the applicant for services. Because all of the services that are provided in the IPE are supposed to help the individual to achieve that employment goal, including, if needed, appropriate AT and personal assistant services. If you are a youth who is still in school, whether that is high school through the age of 21 or even college through the age of 24, what are the transition services that are eligible or that are going to be provided? This can be services such as the pre-employment transition services, which can be self-advocacy assisted, helping somebody with job exploration. So those are services that can be outlined specifically in the IPE. It will set forth what the timeline is for when the services will be starting and when it's anticipated that you will complete that objective or when you will get your employment goal. Are you going to an undergraduate program? They will put onto the IPE that services will start in August 2024 to end by May 2028, because that is the typical time for the bachelor's program. If a service goes beyond that period, then it would be part of a modification to the IPE to extend that period. The IPE will also again set forth the entity who is providing the VR services. And this is one of the important components that I do want to emphasize. You have the right to choose who's providing the services. There will be times with the VR agency where they'll tell you we only have one provider who's providing this service, so you have to go with them. You're not required to make that choice. You can ask them to consider other people or ask that they consider another vendor and have that vendor go through the application process to become a vendor with the state of New Jersey. And the IPE will set forth, and this is one of the important components that I do want to emphasize to you guys, any costs that the individual is responsible to contribute to the VR services. The VR services are not always entirely paid for by the VR agency. Sometimes there is a fee schedule of what they will pay for, say, college tuition. There is also a financial needs test. And again, we will cover that a little bit later. But based off of your income that is counted, whether it's your income or the income of your family, there may be a portion that the VR agency asks you to contribute up into a certain amount before they say that you've made too much money to be able to receive services. So once you've been found eligible for the IPE, what do? Once you receive the letter from the VR agency saying that you've been found eligible, they will have assigned you a VR counselor. You can request the IPE meeting from your VR counselor to discuss your occupational goals. Once you have been found eligible for services, and this is another timeline I would like you guys to be aware of, DVRS and CBVI has 90 days from the date of eligibility to create an IPE. So remember, they had 60 days after you fill out the application to find you eligible. And then once you've been found eligible, they have 90 days to create an IPE. This can be extended, but only through the written consent of you or the person who is applying for the services. It cannot just be an extension that the VR agency decides on their own. If you are seeking tuition support, I would like to emphasize you will need to have an employment goal that would require that additional training, i.e. an undergraduate degree, a certificate, or a graduate program. If you're looking to become a lifeguard, the VR agency will not pay for you to get a master's in psychology. But if you're looking to become a psychologist, they will help you pay for the bachelor's and the master's degree for the psychology. Any of the services that are being provided must be directly related to the employment goal of the individual. So once you've set up and you've requested that IPE meeting, you must notify DVRS and CBVI that you will be attending. And this will be a date that the VR agency will typically contact you and say, here's the dates that are available. Are you available at any of these days and times? And these meetings can be in person, but now in a post-COVID world, they're also still happening by Zoom. You can have any representative that you choose attend the meeting with you. You can bring an advocate. If you're a student who is over the age of 18, you can ask that your parent be part of the meeting. You can ask that a provider be part of the meeting. So you're able to ask for anyone to be part of the meeting that you would like. At this IPE meeting, you will be discussing what your career goal is with the counselor. And this should be a discussion. If you're coming in and saying, I would like to be a medical doctor, they should be talking to you about what does that require, what it's going to be needed. They're going to go over records that they have from your doctors. They're going to go over any assessments that they have. And they're going to have a conversation or should have a conversation with you about whether that is a goal that would work for you. If it's something that you're still not quite sure about, they may recommend, what about being a medical assistant? What about working in the front desk of a medical office so you can get used to working there and see if this is a setting you like? But that's part of the discussion that's supposed to be had with the counselor. If you've realized and say, I want to go to medical school, you will need to identify training programs that you have researched. Say, I want to become a doctor of osteopathic medicine. There is one program in the state of New Jersey that offers a doctor of osteopathic medicine. So you would need to go in and say, here's the training program in New Jersey. If you're looking to go for a medical school, you would need to show the different medical schools that you've looked into to try and figure out which one would be best to suit your needs and which one would best support you as an individual with a disability. Now, I talk a lot about New Jersey schools and New Jersey colleges. One thing I do want to note, you're not bound to attend programs in the state of New Jersey. But if you go to a program outside of the state, There may be some additional requirements that are put into place to be able to show why you need to go to that program. And it may be things like there's no program in the state of New Jersey that offers that. It could be that the other college provides more support. They have an adaptive housing. They have a mentor program that is specifically designed to help people with autism be able to navigate the campus while still attending classes full time. That is something you can speak about with the client assistance program or an advocate on your behalf to help you to figure out what information would be needed to go to that meeting. And then you'll have a discussion with the counselor about the career goals and objectives. So, this is where we were talking about, say, I want to become a doctor. Okay, let's talk to you about what that means, everything that comes into play, all the different training that's going to be needed. Is this going to be a realistic goal for you? Okay, you're concerned about that. Let's look into some other options as well that are still within that same field. And that's supposed to all happen at that first IPE meeting. And from this meeting, the VR agency will then be generating the IPE. Common problems that you may run into at the IPE meeting. The VR agency may say they want to explore guidance and counseling. And when you get your IPE, that is the only service that is provided on that IPE. Why do they do this? It gives them time to help explore career options, but it's not actually providing you any services or supports. It's essentially kicking the can down the road. It's saying, we don't know if we can help you right now. We want to be able to run assessments. We want to be able to get this report from your doctor. We want to get this report from your doctor. Those are all things that should be happening before they have determined the eligibility. So if the VR agency says, we want to give you an IPE for guidance and counseling and send you to an AT assessment, again, they're just trying to stall for time to try and figure out what services to provide for you. You may agree with that, but you can also sit there and say, I want an IPE that provides me services for these things while I'm also going for that assessment. Do not think that you have to delay services while you're getting the assessments. We know that the VR agencies may try to say that or try to push that, but it's not required. You could be receiving the assessments at the same time you're receiving services. You can also run into the VR agency may not agree with your career objective. This is where that informed choice comes into play. Every VR client is to be given informed choice, including the ability to have a say and choose their employment goal. The VR agency may seek to change your career objective to meet their plan rather than what you're seeking. What does this look like? You may be somebody who comes in and says, I want to become an attorney. And the VR agency says, okay, we'll help you become a paralegal. A paralegal may be in the same field as an attorney, but it's not the same equivalent. That's not really having a conversation or letting you as the client have a say in what your career goal is. What they're supposed to do is to say, okay, you want to become an attorney, let's discuss it. We've also seen situations where somebody has come in and they say, I want to become a medical assistant, and they receive an IPE that says they're going to be a general retail worker. Very different field, not at all related to what they want to do. And one of the concerns with that is with the VR agencies, they're choosing their job goals from a drop-down box in a program that they have, which doesn't allow for a lot of individualization. So that's one of the issues that I know the client assistance program is currently trying to address with them, because it's not letting people really have a say in what they're looking to do. Common problems with IEP development and continued. The VR agency will select your employment goal or disagree with your objective. This is kind of what we were just talking about before. They're not giving you a say in your employment goal. They're not giving you the chance to have your wishes heard. They may have an appropriate employment goal on it. Say you want to become a lifeguard, but they're not providing you with any services to help you become a lifeguard. They may only provide guidance and counseling services again, but not provide any additional supports. Are they providing job coaching? Are they providing you with training for the lifeguard services? If that's not on the IPE, you don't have to sign it. If you're somebody who knows that you're going to need a bachelor's degree and potentially a master's degree to be able to pursue your employment objective, they may refuse to include sponsorship for tuition on the IPE, despite it being a necessary credential. It may be generated saying, I want to become a teacher, but they won't provide you with the education to be, or the training to be able to help you become that teacher. And another thing that I do want to note, especially if you're somebody who is coming into the VR agency, you're already in your sophomore year, your junior year, they may say they won't agree to tuition if you've already enrolled in the program. And they may say that you've enrolled without them or without discussing it with them. Sponsorship, if appropriate, could be for subsequent school years, but the VR agency may be hesitant to do so. And part of it at that point, what you're showing them is, I want to become a teacher. This is the program that I would like to go to. Here's been my grades with this program. Here's the assistance that I need to be able to get through it. I would like sponsorship and assistance for the next 2 years, next 3 years of my program. Every year of the VR agency, every year it's tuition is supposed to be a new IPE or the new IPE development. So you can go to subsequent years with tuition. It's not they start at the freshman year or nothing. They are supposed to take each year individually as it comes up. And this is what we were talking about with the financial needs test. Generally, VR agencies are not required by federal law to do the financial needs test, however, many do. And DVRS and CBVI both use the financial needs test to determine if you would need to contribute to the cost of the VR services. If you are a student under the age of 22, your entire family income will be considered. If they're living at home, if you have a brother or sister who's living at home, their income may also be counted. Otherwise, the income of your parents will be used. The parental income will not be considered when they're developing an IPE if you are 22 years or older as of January 1st for the year that the services are being scheduled. At that point, they would only be considering your income or your spouse's income. There is a caveat to that. I will talk to that in just a moment. This is the DVRS financial needs test. If you have two members of your family, say it's you and your father, you and your mother, and your father is making $75,000 a year, you may be seen as being over the financial needs test. So that means that you would likely need to contribute to the cost of any of the services that you receive from the VR agency. And this chart came from the most recent allowable income limits for services from DVRS from their 2021 report or manual that is published on their website. If you are an SSI or an SSDI recipient, this is what I was talking about, is there's a little bit of a caveat or an exception to this. SSI and SSDI clients are exempt from the financial needs test. So if you are somebody who is who is 18, under the age of 21, and they would be considering the family means or the family income, if you are eligible for SSI or SSDI and you are receiving benefits, they cannot look at the amounts that your parents are receiving, regardless of your age. Another thing to note, SSI and SSDI clients are not required to financially contribute to any of the VR services. So when we're talking about the pro rata share, or the client is paying for a portion of the VR services, if they are receiving SSI or SSDI, they cannot be requested to contribute to those amounts. So say you're now going for tuition services. You will need the IPE to set forth that they're providing the services. And this will include a budget that will be on the IPE of what services they will be providing and how much they will be providing. So this is where the VR agency may provide a sponsorship per credit that you're taking or per semester. But either way, like say if you're having an IPE for tuition and you're asking for 4 years of tuition, if the VR agency was paying up to $6,000 per semester, they would need to put $96,000 that they were going to be paying towards your education for $6,000 a semester. Please don't check my math. That was just me trying to do it in my head. I apologize. There will be the two considerations for the financial needs test, or for the tuition. One is that financial needs test. What is the income of the family? If it's somebody who is SSI or SSDI, again, the family income will not be considered, and it will just go off of the SSI and SSDI amount that the individual receives. But there's another portion that will be taken into account with the IPE if you're looking for tuition. But this will also go towards any services that could be provided by another agency or another program, such as your insurance. And that's a comparable benefit. And we'll talk about that just a little bit about how that looks for tuition. But for tuition, the comparable benefits are need-based scholarships and grants. The IPE in the budget should identify what portions of the tuition are being covered by these other benefits, what's being covered by the VR agency, and what, if any, portions are being paid for by you as the person who's receiving the benefit. Comparable benefits are benefits or services provided in whole and part by another public entity, public agency, health insurance, or as an employee benefit. These can be things like Pell Grant, Medicaid, Medicare, private insurance. VR agencies are required to check whether other funding sources are available to provide these comparable benefits, i.e., the services, prior to funding a specific service. If you're going to the VR agency and you're asking them for psychiatric treatments, they're going to ask, are those covered by your insurance? Were they denied by your insurance? If you're going to the VR agency asking for assistance in receiving a wheelchair, a piece of durable medical equipment, they're going to say, did you submit this to your insurance? Did the insurance approve it? Did the insurance deny it? Is there a portion that you're being forced to pay or that you have a copay for that we may be able to help with instead? The comparable benefits must be benefits that are currently available to the VR client. So this isn't something where the VR agency says, well, this person's saying they could be eligible for Medicaid in 6 months, so we're not going to provide the service now, and we'll revisit it in 6 months after you've submitted it to Medicaid. Why? Because that's not a benefit that's available to the individual at that moment. The only thing that they're able to look at is, what are the services, if you look at somebody as a whole right now, what are they entitled to? What benefits do they have? If your insurance doesn't provide durable medical equipment coverage, the VR agency may step in to be able to provide that service. If your insurance doesn't provide more than 5 mental health sessions per year, the VR agency may provide additional services. What are not comparable benefits? And this is specifically for the purposes of higher education, because these are the ones that are specifically outlined in the federal regulations. Awards and scholarships that are based off of merit are not a comparable benefit. So if you've received a scholarship, if you've received a grant from your school that's based off of your merit, that you had scored high enough on your SAT, that you have a high enough GPA, the VR agency is not to use those as the comparable benefits. That's not a credit that they would be able to get to say, well, if your tuition is $40,000 a year, but you're receiving $32,000 in merit-based scholarships, they're not looking at only at that $8,000. They're looking at the full $40,000 because that merit scholarship does not count for the calculation. And the other one that I really want to stress is not a comparable benefit is student loans. You will be required to fill out the FAFSA, the free application for financial aid, for student financial aid, but based off of that number, they cannot say, well, you're eligible for the subsidized loan. You're eligible for the unsubsidized loan. You can get a Parent Plus loan to be able to provide services. So get those, and then we'll cover any balance, because a student loan cannot be considered as a comparable benefit. So one of the things that we do point out, especially since we're now in June and we're coming up into July and college is starting in August, we do want to make timeline if you're looking for tuition sponsorship available. Again, they have 60 days from the date of the application to make the eligibility determination. And then they have 90 days after eligibility has been determined to develop the IPE. So combined, it can be 150 days or about 5 to 6 months from application to the IPE being developed. If you're looking to go to school in August, you should start the process in January or February, but you can also start the process now in June to begin the process, to begin the eligibility. Or if you've already been found eligible for services, request the IPE meeting now to be able to be ready for August. So if you have any concerns with the process, if you have any concerns during the application and the eligibility process, what can you do? You can always contact your VR counselor for updates. If you've applied for VR services, if you've been referred to VR services, you will have a vocation rehabilitation counselor who has been assigned to work with you, and they should have reached out to you so you would have their phone number and their email. If they're not responding to you, you can contact the manager of the VR office that you're working with to be able to get updates. It could be that your counselor is out of the office unexpectedly. It could be that they're out on an extended medical leave. But the manager is supposed to be overseeing and would be able to step in and either get you a new counselor or get you the information that you're looking for. You can also contact the client assistance program to be able to find out, is this timeline unreasonable? What do I do if I have any questions? What do I do if they're asking for a doctor's note that specifically says, is this person eligible to work? You can always give us a call here at the CAP and we can go over that with you. So now that brings us to, what do you do if a service is denied? Because you've gone to the school, to the VR agency, you've requested these services, you've requested the IPE, and they go no. What do you do? They must give you written notice of services or the denial of services. And they must send this written notice, this written denial, if you apply and you're being told you don't qualify for services, or you've already been somebody who's receiving benefits, and now they're telling you that you are unqualified for services. You also need to have it in writing when you're developing an IPE, when your services are being changed, or when you're being referred to any other agency for assistance. What must be included in the notice? The notices must tell you what service is being denied and why it's being denied. It can't be just that they're saying, we're not providing you this service and not giving you a reason. It must also provide you with information that you need to be able to appeal the decision. And there's going to be 4 levels of appeal that you would have an option to go to that we're going to go over in detail. And they must provide you the information for the client assistance program. Why? Because the client assistance program was created by the Rehabilitation Act along with the VR agencies to act as the body to be able to help provide assistance and information to help you understand what's going on with the VR agency. So it's actually specifically written into the law and into the federal regulations that you must be provided with the CAP program information. What's really happening though? DVRS has routinely informed clients of case closures or denial of services through phone calls, verbally at IEP meetings, or in an email. These notices do not have any of the how do you appeal? What are your rights to appeal? If somebody's getting a phone call saying, we're not paying for this wheelchair, well, how do you then appeal from that phone call when they can turn around and put in their notes, oh, we spoke with them and they said they don't want the wheelchair? Well, now you have nothing in writing except those case notes that say what happened. CBVI notices we have found are more comprehensive and they do provide proper notice to clients of how to appeal the adverse decisions. It's a much smaller agency, so that's also partially why they're a lot more detailed with their notices. We know that DVRS is currently in the process of working on and amending their notices, and we're looking forward to having those notices being implemented within the next few months. You have the right to appeal any decision of the VR agency. Whether you have been given your appeal rights in writing or not, you absolutely have the right to seek review of a decision that you do not agree with. This is one thing that I do want to stress, want to emphasize. You can always appeal a decision. You do not have to just say, oh, the VR agency is saying no, I guess I can't have that service. You start with an informal review of it. And this is requesting the review in writing. This goes to the VR counselor to say, I'm not happy with this decision. Can I get a second set of eyes on it to review the work? Can I get a second set of eyes to look at my information and what I'm requesting to see whether or not it is appropriate? If you're not happy with the informal review, again, this is the informal review is just a discussion. It's a discussion with the supervisor. If it's a discussion with the manager of the office, they may agree with the VR counselor. You can appeal that decision. There are 3 levels of appeal after you've done that informal review. That's an administrative review, mediation, and requesting a fair hearing with the Office of Administrative Law. The administrative review is a review by a panel of VR agency staff and is the least formal of the various appeal options. You can request this in writing to the VR office, and this is either in letter sent via regular mail and email asking for the administrative review. And then once they've received that request, the VR office should be reaching out to schedule the meeting within 14 days of receiving the review to arrange a time and location. This isn't saying that the review should happen within 14 days. This is saying that after you've requested the administrative review, the VR agency has 2 weeks to reach out to you to begin scheduling. So what then happens at the administrative review? Typically, they're at one of the VR agency's offices in a conference room large enough to accommodate everyone safely. I do say safely, especially in this post-COVID world. You may need some distance between you. And the administrative review is an opportunity for both you and the VR office to discuss any of the concerns of the service in question and to help you determine whether or not it's appropriate or whether there's an alternative that could be recommended. It's important to note you will not receive a decision at the administrative review. These are informal with DVRS, it is an informal discussion. Everybody's sitting at the table, really having just a discussion back and forth, sharing information and reviewing documents to see whether or not a service that you've requested is appropriate. With CBVI, it is a little bit more formal, and you will have a panel that you are presenting information to. You'll be saying why you think that a service is appropriate, and CBVI will be saying why it's not appropriate. After that administrative review, the VR staff will have to review their notes and you'll receive a written decision. With DVRS, they will be submitting a recommendation to the Assistant Executive Director and the Executive Director to be reviewed. With CBVI, the panel will issue an initial finding that will be sent to both you and to the Executive Director. And if you object to anything it's in the initial decision or initial finding, you'll have the opportunity to put in some comments or concerns about it. After that, both agencies will send a written final decision from the Executive Director to you saying, we agree with the decision of the VR agency. We disagree with the decision of the VR agency. We disagree with both of you and suggest this instead. And so that final written decision is the final note of the administrative review. But that's not the last step if you're not happy with that decision. The next step after that, you have 2 options. You can either go into a mediation or request a mediation, or you can request a formal fair hearing in the Office of Administrative Law. Mediation is a more formal proceeding where there will be a mediator appointed to listen to both sides to really try and help reach a resolution. And one of the benefits of this is the mediator is an independent third party who is not affiliated with either you or the VR agency. And they can really then act as an impartial decision maker and be unbiased when they're trying to help figure out and determine whether a resolution can be reached. I do want to note, while you are able to request this, right now, neither VR agency is actually accepting mediation requests due to a shortage of mediators in New Jersey. You can always request it, and they could be a new crop of mediators that has been approved by the state, and they can agree to go to a mediation. But typically, this is not something that you will see all that often, but we're still explaining it to you because it is a legal right to request. You must request the mediation in writing. And this is a formal letter sent to the agency, whether that's if you're appealing for or requesting a mediation for DVRS, it goes to the Assistant Director for Field Services at the Trenton office in the John Fitch Plaza. And if you're talking about CBVI, it goes to the Administrative Office in Newark, New Jersey. I'm going to leave this slide up for a quick second if you guys want to take a screenshot of it. Otherwise, this information is in the PowerPoints that will be posted, and it's also in the self-advocacy guide that we now have posted, helping walk you through this entire process. Okay. So what happens after a mediation has been requested? Once a mediation has been agreed to, and again, this is voluntary, so you can request the mediation, and the VR agency can say, we don't have any mediators, or we're not going to agree to a mediation. They will then, if they say they will agree to it, they will request a mediator within 30 days of the written request. If they're unable to identify or secure a mediator, the VR agency must provide written notice within 30 days of the initial request, which will then allow you to file for a fair hearing or an administrative review as needed to seek a review of the decision. So you could file for the mediation first and then say, okay, I don't want to go quite that formal. Let's go back to administrative review. Or you can go to the Office of Administrative Law. But you cannot go from administrative review to mediation and then back to administrative review. Once you have used a particular appeal form, you're not able to go back to it. What happens at the mediation? These are more formal procedures, and they're typically held at the mediator's office or at a location selected by the mediator that may be central for all parties. And typically, you and the VR agency will start in the same room to just introduce yourselves to the mediators, do a brief overview of why you're here, and maybe a brief summary of why the parties are here. Then you'll be separated into different rooms, and the mediator will ping pong back and forth between the rooms to discuss the case with you. They'll come and usually to start with discussing it with the petitioner or the individual filing the appeal to say, what's your position? What are you looking for? What's your hopes to get out of this? They'll then go and talk to the VR agency and have that same discussion with them. Once the mediator has that little bit more of information, they'll be going back and forth between both you and the VR agency to have a frank discussion about the merits of the case, what the concerns are, why the VR agency may feel that a job coach isn't necessary, why they think that a service isn't necessary. They'll be bringing to the VR agency why you feel that it is necessary and what the supports are to try and help both parties reach a resolution. If you reach an agreement with the VR agency, the mediator will help you to draft a formal agreement, which is then signed by you and the agency. If you reach an agreement and you have that signed mediation agreement, this now serves as the basis for creating the IPE because they have agreed that you have both agreed that a service will be provided or that a service will be modified. If you do not reach an agreement with the VR agency, the written decision won't be generated. What you will get is a notice from the mediator that says that the mediation was unsuccessful, and you then have the right to request the fair hearing to go before the Office of Administrative Law. The third appeal step, and this is just for the administrative appeals, is the impartial fair hearing. This is the most formal of these appeal processes. This must be requested in writing in a formal letter that is sent to the VR agency. This does not have to have all the information or reasons for the appeal. And this is where the Office of Administrative Law is a little bit different than, say, going to the state superior court or into the district court, where when you file your complaint, you have to list everything that you are challenging. For this, you can send a simple paragraph. I disagree with the decision of the VR agency regarding tuition sponsorship dated May 20th, 2024, and requested this be referred to the Office of Administrative Law as a contested matter. That's all you need to put. You don't need to say, based off of this law, this regulation, or these different things. All you have to do is just let them know you disagree with the decision and you'd like it to be transferred to the Office of Administrative Law. This request goes to the agencies, and this is again the same information, the same place that you would send the request for the mediation. So if you've already taken a screenshot, you already have that information up, but I'm just going to pause for about 10 seconds to let you guys take a screenshot for it, and then we'll move on. Okay. Once the VR agency has referred the matter to the Office of Administrative Law, an administrative law judge will be assigned. We do want to note that if you're representing yourself pro se, or if you're going and representing yourself through this entire process, the VR agency will be represented by a member of the Attorney General's office. So any inquiries or letters regarding this issue, regarding the case that you have with the VR agency that is before the OAL, will go to the attorney rather than to the agency directly. This does not mean that you can't speak with the agency about another issue or about a subsequent year or a different service, but you cannot speak with the agency or your VR staff about the specific service that you're currently in a fair hearing about. And while you may represent yourself at the fair hearing, it is strongly encouraged that you seek representation of an advocate or an attorney, such as the Client Assistance Program, to be able to help you through this because it is a very formal proceeding. Your first meeting with the court will be a status conference, and this will be an initial hello, Your Honor, how are you? Let's figure out why we're here, and let's have both parties give a brief introduction as to where they see the position of the case. At that point, the court will ask if there'll be an exchange of discovery. And what is discovery? Discovery is information that you think you may need that the other side has that you're not otherwise able to access. So this could be something where if the VR agency is saying, we're denying this service based off of this policy we've created, you can ask for information about how they created that policy. You can ask for a copy of that policy if they haven't already provided it to you. So those are all things you can request during the process of getting discovery. If either side says, yeah, we think we need some information from the other side, the court will set a schedule for the discovery. If both parties go, nope, we think we're good, we don't need any information, we just want to go and be heard before the court, they will set a date for your trial. One thing I do want to note with the Office of Administrative Law that is different from what we may see on TV when we talk about courtrooms or courtroom dramas, the fair hearing will be heard by the judge only. So there's no jury in the administrative process. So you're not turning and talking to the jury box. You're not going with these very detailed exhibits to try and paint the picture for everybody. You're just talking to the judge. The judge will hear brief opening statements from both you and the VR agency on the day of the hearing. And then after the opening statements, you will each present your case. And so what does that mean by presenting your case? You'll have the opportunity to call witnesses to be able to help support your position. And you'll be able to ask them questions to help the judge really get an understanding of what you're seeking, why you're seeking it, and why that service would be beneficial for you. Then the VR agency will have the opportunity to question those witnesses, to be able to say, is there any other service that may be able to assist them? Is that the only thing that they have considered? Then the VR agency will also put forward their witnesses. Why was this policy implemented? Why was this decision made? What has the relationship been with the VR counselor and you to be able to talk about, has it been reasonable? Have they tried to work with you? Typically the answer may be no, but that will come out with your testimony and your discussion with the court, where they're going to try and paint themselves in. Of course, we do everything. We are by the books and make everything all perfect and nice. Both parties are going to be presenting their case in the light most favorable to them. And that's part of the reason why we go before the judge, because the judge is listening to both parties and will make a decision based off of the position that he's heard from both parties. Then after the impartial hearing, after both sides have gone in and really presented their case, The court will ask you and the VR agency if you'd like to make closing statements or if you'd like to submit written closing statements. Typically, the Attorney General's office will ask to make written closing statements, which will then typically be due about 30 days after the actual hearing to give the parties a chance to write the briefs. Once the court receives the closing statements, either the day of the hearing or in writing, they will then close the record. After the record has been closed, they will have 45 days to issue a decision from the date that the record is closed, but they may request additional time as needed from the Office of Administrative Law. So if you don't have a decision within 45 days, one still may be coming. They may have a question of law or question of fact that they're still looking into, or it could be the judge was so swamped, we saw this coming out of COVID, that they needed additional time to be able to catch up on the backlog of cases. But wait, that is not the final decision. Even after you receive the decision of the administrative law judge, that is not the final say of the case. That decision will then go to the agency, which is the Department of Labor and Workforce Development for DVRS and the Department of Human Services for CBVI, and the decision would then be reviewed by the director of those various agencies. The director of the agency will then issue the final agency decision, which becomes the final word of the administrative law appeal. And there's usually three ways that they can go. They can say, yes, we absolutely agree with Your Honor. This is a very well-reasoned decision, so we are going to affirm this decision. They can look at a decision and go, we completely disagree with you, Your Honor. How dare you make this decision? This is not supported by law, or we're going to adhere to our internal policy and overturn your decision. They can also say, we agree with you in some parts and disagree with you in other parts. So we're going to affirm this part of the decision, and we're going to deny this part of the decision. Once they have that final agency decision, that will be the end of the administrative appeals. I want to note that's the end of the administrative appeals. Because if you disagree with that final agency decision, there still are additional options for appeals. These involve either going to the state appellate division or to the District Court of New Jersey. But if you're taking these routes, it is highly, highly, highly recommended that you get legal counsel working with you on these if you haven't already brought someone in. And this is something that you could, again, contact the client assistance program with, and we can be able to provide assistance. And if we're not able to provide the representation, we can get you in touch with an agency that may be able to. We are here to help you. As a VR applicant, you have the right to contact us at any step in the program and the process. We're here to help answer questions, provide counsel advice, and to really help you understand your rights and be able to provide that no-cost legal advocacy throughout the process. So please don't hesitate to reach out to the Client Assistance Program at any point in the VR process. We're always here to help. We're here to give advice. We're here to help you explain your rights. And if you're looking to do things on your own, we can provide you with advice and counsel on how to request things, how to phrase things, to be able to present it to the VR agency to really be able to assist you. And with that, I will ask if there are any questions. Seeing no questions, I am putting up our contact information. This is the main contact information for our agency, including our phone numbers and the email that you can send an email to if you are looking for any assistance. And I will leave this up for a couple of seconds. And then I will go to our last page, which has all of our social media accounts where you can also find and follow us. And our social media can be found on Facebook, Twitter, Instagram, LinkedIn, and YouTube. We also have our website up for it. And we would like to thank you for coming to our presentation. This information will be shared up on our website, and it will be made available for everyone to come and be able to view, where we also have our self-advocacy guide to be able to help you walk through this process as well, and complete with the links and more information and more details for things like, what do you wear when you're going to a courtroom? How should you act? Things like that you can find in our self advocacy guide. Thank you so much for being here.